Hi guys, and welcome to another episode of Attorney Javier's Law Lectures for Students. Today we'll be having an overview, or as may be applicable, a review of competition law in the Philippines. Note that as an overview, the discussion today will be more general in nature and some details may be omitted. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. A like on this or any of my other videos would also be greatly appreciated. This episode is brought to you by Digest.ph, an online law library with over 80,000 case digests and full texts of Supreme Court decisions, all downloadable in Word and PDF formats. Use my promo code Javier Digest to get 20% off Digest subscription plans. Now, let's begin with our discussion on Philippine competition law, beginning with the question, what is competition? While the law does not expressly define the term, competition may be described as a situation in a market in which sellers independently strive for the patronage of buyers in order to achieve a business objective such as profit, sales, or market share. In other words, competition is a process of rivalry between businesses where they try to attract, convert, and retain customers, increase revenue, and gain more market share, such that if they do not compete successfully, they may lose business to their competitors. Thus, suppliers have an incentive to lower prices, enhance efficiency, increase output, and improve the quality of their products so they can attract more customers and take business away from their competitors. As such, competition keeps the economy working because, first, it encourages multiple buyers and sellers to interact with no single entity controlling the price of goods or services. Second, it encourages companies to play fair. So no company benefits from undue advantage, making it easier to start and operate new businesses and allowing small businesses to compete with bigger businesses on fair terms. And third, businesses pay more attention to consumer demand and they have to innovate to make their products different and better than the rest. So, when businesses compete, everybody benefits. Consumers, they benefit from lower prices, more product choices, and higher quality of goods and services. While businesses also benefit from competition as it ensures that they can access at reasonable cost supplies and inputs that they need for their enterprise, such as raw materials, labor, and financing. Now, competition law or antitrust law is the set of rules and regulations that safeguards competition. It implements competition policy and it protects the competitive process within the market for the benefit of the consumers. In general, the objective of an antitrust law is to ensure a competitive economy based on the belief that through competition, producers will strive to satisfy consumer wants at the lowest price with the sacrifice of the fewest resources. Competition law is not meant to protect specific competitors. Rather, what is being protected is the overall competition in the market. Now, the governing law on competition in the Philippines is Republic Act number 10667, otherwise known as the Philippine Competition Act or PCA for short. And this took effect in 2015 and was enacted in line with the goals of the national economy as set forth in Section 1 of Article 12 of the 1987 Philippine Constitution, okay, which include achieving first, a more equitable distribution of opportunities, income, and wealth, a sustained increase in the amount of goods and services produced by the nation for the benefit of the people. Third, an expanding productivity as the key to raising the quality of life for all, especially the underprivileged, as well as the constitutional mandates of fourth, regulating or prohibiting monopolies when the public interest so requires, and ensuring that fifth, no combinations in restraint of trade or unfair competition shall be allowed. So, the PCA is the antitrust law of the Philippines, and it is the law which promotes and protects market competition. How? By ensuring fair competition between businesses through defining, prohibiting, and penalizing anti-competitive practices. It applies to and therefore covers first, any person or entity that is engaged in any trade, industry, and commerce in the Philippines, and also to international trade that has direct, substantial, and reasonably foreseeable effects in trade, industry, or commerce in the Philippines. And this includes those that result from acts that are done outside the Philippines. So this gives the PCA extraterritorial effect. Okay? So the Philippine Competition Commission, or PCC, has jurisdiction over such international agreements provided they have direct, substantial, and reasonably foreseeable effects in trade, industry, or commerce in the Philippines. Okay? And this allows the PCC to enforce the PCA to protect competition within the Philippines. Note that the PCA does not apply to collective bargaining agreements or other arrangements between workers and employers or other activities affecting conditions of employment. However, non-compete clauses, these are covered by the PCA, okay? Especially where they result in a substantial lessening, restriction, or prevention of competition. Okay, so those are keywords, the substantial lessening, prevention, and or restriction of competition. You will encounter that throughout this discussion. Now, as its policy, the PCA recognizes that free and fair market competition promotes entrepreneurial spirit. It encourages private investments and facilitates technology development and transfer, as well as enhancing resource productivity. The PCA further recognizes that competition serves the interest of consumers. How? By allowing them to exercise their right of choice over goods and services that are offered in the market. Therefore, the policy of the PCA considers the interests of both the businesses and the consumers. Okay? A level playing field for businesses and promotion of consumer welfare. Ultimately, competition law is founded on the principle that free and fair competition is the best way to organize a market. Thus, competition law has two goals in general, no? To promote free and fair competition in the market and consumer welfare, which is the satisfaction with price, quality, choice, and innovation of goods or services. Okay? Note, however, that consumer welfare is different from consumer protection. Okay? One of the goals of PCA is consumer welfare, while consumer protection, on the other hand, is ensured through the Consumer Protection Act, which we will talk about in a different episode. To emphasize, the competition that the law seeks to promote is fair competition, which refers not only to fairness between the seller and the consumer by serving as motivation for companies to provide convenient and fast services or better products, but also between competitors offering similar goods or services, which creates a level playing field among businesses, which in turn encourages investments, creates more jobs, and increases consumption. Thus, with healthy competition, the country can enjoy economic growth. Now, To achieve its goals of promoting a free and fair market competition and protecting consumer welfare, the PCA relies on three pillars. Namely, first, the prohibition against anti-competitive agreements, which prevents entities from entering into an agreement that will enable them to exercise greater market power. Second, the prohibition against abuse of dominant position, which prevents a dominant entity from abusing its market power to exploit consumers or to exclude its rivals. And third, the prohibition against anti-competitive mergers and acquisitions, which prevents transactions that can create an entity which can exercise greater market power or can make the market less competitive such that the remaining entities can exercise a greater market power. Now, these three pillars also serve not only to discipline the behavior of market participants, but also serve as a check on the exercise of market power, which is simply the ability to raise and maintain prices in a competitive market. Now, under the first pillar of anti-competitive agreements, the PCA makes it illegal for business rivals to act together in ways that can limit competition, lead to higher prices, or hinder other businesses from entering the market. Specifically, the PCA prohibits anti-competitive agreements in any and all kinds of form, whether formal, informal, express, implied, written, or oral, and even a nod and a wink. Okay? Nod and a wink. As long as business rivals act together in ways that limit competition or hinder other businesses from entering into a market in a way that substantially prevents, restricts, or lessens competition, then that is prohibited. Under Section 14 of the law, there are three categories of anti-competitive agreements. First, we have the per se prohibited agreements under Section 14, Paragraph A. And these are so inherently illegal and damaging to the market that they are conclusively presumed to be anti-competitive even without the need to inquire into their object, actual effect on the market, or the intention of the parties. All that is required is that the anti-competitive agreement was reached for it to be punished. Again, the only proof is that the agreement exists. Examples are price fixing and bid rigging. Price fixing is when businesses agree to directly or indirectly fix the selling price instead of letting supply and demand determine the price of goods and services. In other words, competitors restrict competition by agreeing on the prices of goods or services rather than independently setting their own respective prices. Bid rigging is when businesses coordinate their bids and agree to fix prices at an auction or manipulate bids rather than to submit independent proposals. And this forces buyers to pick the higher priced pre-selected bid instead of the price that's more favorable to the buyers. And some forms of bid rigging include cover bidding, bid suppression, bid rotation, market allocation, and others. The second category under Section 14, Paragraph B are agreements that have the object or effect of substantially preventing, restricting, or lessening competition. Unlike per se prohibited agreements under Paragraph A, which merely require proof of the existence of the agreement, these agreements under Paragraph B require the PCC to conduct an object or effect analysis, which is an inquiry of whether or not, first, the object of the agreement is to restrict competition, and if not, then second, whether the agreement has the effect of restricting competition. That's why it's object and effect analysis. If either the object or the effect of the agreement substantially prevents, restricts, or lessens competition by either contributing appreciably to the inability of new competitors to enter into the market or for existing competitors to expand, then that is prohibited. Okay? Examples are output limitation and market sharing. Output or product limitation or supply restriction is when businesses agree to limit production by restricting the volume or type of goods that they produce or make available for sale, and this creates an artificial shortage of supply in the market, which drives up prices. Market sharing is when businesses agree to divide the market and claim dominance according to territory, customer demographic, sales volume, or type of goods or services, among other factors. Okay? And this also creates local monopolies that would keep prices artificially high and deprive consumers of choice on price and quality. The third category of agreements under Section 14, Paragraph C, is a catch-all provision which prohibits those agreements that are not covered under Paragraphs A or B, but which nevertheless have the object or effect of substantially preventing, restricting, or lessening competition. The same section, however, provides for the efficiency defense, which holds that these agreements under paragraph C are not necessarily illegal if they contribute to the improving or the production or distribution of goods and services or to promoting technical or economic progress while allowing consumers a fair share of the resulting benefits. Okay? Now, the first two categories, A and B, are sometimes known as hardcore cartels, which are organizations formed by competitors in a specific industry that enable them to set prices or control levels of production. By nature, paragraphs A and B are horizontal in agreement are horizontal agreements as they are made between businesses in the same stage or level, such as when three different sellers agree to sell their goods at the same price. Whereas the third category under paragraph C are vertical agreements by nature, as they are those made between players in the different stages of production or distribution, such as when a producer colludes with a distributor to influence the price of the goods sold to consumers. To fall under the prohibition, anti-competitive agreements must have three elements. First, there must be two or more separate entities. Okay, there can be no anti-competitive agreement between components of a single entity. So, following the single economic entity concept under Section 14, if an entity controls, is controlled by, or is under common control with another entity or entities which have common economic interests and are not otherwise able to decide or act independently of each other, then they shall not be considered as competitors. Example, if a subsidiary, even if it may have a separate legal personality, if it cannot act independently because it has to follow the instructions of its parent company, then there is no anti-competitive agreement because they will be considered as a single economic entity. Okay? The anti-competitive agreement, again, first element must be between two or more separate entities. Second element, the entities enter into some form of agreement. Okay, so any form, even a nod and a wink. And third, the agreement is either anti-competitive per se or has the object or effect of substantially preventing, restricting, or lessening competition. To reiterate, Not all interactions between competitors are collusive and prohibited, because businesses may still interact for transactions and conduct assemblies for legitimate reasons. It is only when the competitors enter into anti-competitive agreements that they may be held liable under the PCA, specifically if the agreement is either per se prohibited or if the object or effect of the agreement substantially prevents, lessens, or restricts competition to such extent as to prevent either existing companies from expanding or new competitors from entering into the market. Moving on to the second pillar of abuse of dominant position, otherwise known as unilateral conduct or misuse of market power, the PCA prohibits an entity, company, or even an individual which holds a dominant position in the relevant market from using its dominant position to substantially prevent, restrict, or lessen competition. Why? Because it ultimately harms the consumers. To emphasize, it is not illegal to be dominant, as the law does not punish the successful growth of business, which will only lead to discourage investment and innovation. Rather, what is prohibited is the abuse of the dominant position. So, to determine whether there is a violation, you first determine whether a business is dominant. Because if the entity is not dominant, then it cannot violate Section 15 of the PCA because it cannot substantially prevent, lessen, or restrict competition in the relevant market. We can say that a business becomes dominant in a certain industry if it has gained a significant share in the relevant market, which is a combination of relevant market, meaning a combination of the relevant product and the relevant geographic markets. Okay? Or we can also say that a business has become dominant if it has become an industry leader because of the number of years of its operation. Okay, nevertheless, Section 4 defines a dominant position as a position of economic strength that an entity holds, which enables it to control the relevant market independently from competitors, suppliers, customers, or consumers, or a combination thereof. Now, dominance can exist either on the part of one entity, in which case it is unilateral conduct or single dominance, or it may exist on two or more firms, which results in collective dominance. Some factors to determine whether a business has a market dominant position include: first, the share of a firm in the relevant market and whether it can fix prices on its own or restrict supply in the relevant market. Second, whether there are barriers to entry in the market. Third, the existence and power of other competitors. Fourth, whether there is a credible threat of future expansion by competitors or entry by potential competitors. And fifth, the power of customers to switch to other goods or services, and other factors which may be found under Section 2 of Rule 8 of the implementing rules of the PCA. In any case, if an entity has at least a 50% share of the relevant market, then it is presumed to have a market dominant position. Again, just being dominant is not prohibited. There is no violation if the dominance, acquisition, maintenance, and increase of market share is either acquired through legitimate means, such as having better skills, superior services, or higher quality products, and does not substantially prevent, restrict, or lessen competition in the market. Okay? Businesses that behave competitively and achieve or maintain a dominant market position legitimately are not in violation of the PCA. Nevertheless, in the conduct of their business, dominant companies, considering their size, scope, position of economic strength, they may have a disproportionately severe effect on the market. Markets that are dominated by a single or a handful of large companies are particularly vulnerable to anti-competitive practices. So, where the acquisition, maintenance, or increase in market share, in other words, the dominance, is caused by conduct that substantially prevents, restricts, or lessens competition, then the PCA is violated. Thus, business entities, whether companies or individuals, that have a significant degree of power in the relevant market are prohibited from exploiting their dominant position by engaging in conduct that would substantially prevent, restrict, or lessen competition. So, when can we say that a business is abusing its market dominance and violating the PCA? Section 15 provides a very long list, which you can read on your own. Okay? But generally, an entity can be said to be abusing its dominant position when it engages in conduct that substantially prevents, restricts, or lessens competition, including one, predatory pricing. Okay, which under paragraph A of section 15 is when a dominant firm deliberately incurs losses in the short term by selling goods or services below the cost of its production, which can eventually force its competitors out of business because they cannot meet the same low price. Okay? Now, another is exclusive dealing under paragraphs B and E. Okay, where a dominant firm requires or induces its customers to not sell products or services of its competitors. Okay, exclusivity. So, this is done either through direct contractual stipulations or indirectly through loyalty rebates and bonuses. Okay? Now, generally, loyalty rebates and bonuses are fine, but they may be anti-competitive if there is a minimum quantity requirement. Okay? Such that the effect is it becomes an exclusive purchase agreement. Okay? And these will only be allowed if the exclusive franchise, license, or distributorship agreement gives each party the right to unilaterally terminate the agreement. Okay? Or also in case of agreements which protect intellectual property rights, confidential information, and trade secrets. Okay? Another example of an act constituting abuse of dominant position is tying and bundling, okay, under paragraphs C and F. Tying is when the purchase of one product, known as the tying product, depends on the purchase of a second product, known as the tied product. Okay? Bundling is when two products are only offered for sale in a bundle. While these may sometimes be beneficial to consumers, it is prohibited if it is done to exclude competitors from the market because it will ultimately harm consumers. We also have price discrimination under paragraph D, where the dominant entity imposes different prices or different terms and conditions for the same products or services for similarly situated customers without any commercial justification. The only permissible price differentials are socialized pricing for the less fortunate, commercial differences in the cost of supply, and differences to compete with a competitor or with changing market conditions. Another example is unfair pricing, which can be either imposing unfairly low prices for goods or services of marginalized producers or service providers under paragraph G, or imposing unfair prices on competitors, customers or suppliers, or consumers under paragraph H. We also have the margin squeeze under paragraphs B, D, and H, where the dominant entity sets prices for the input or the unprocessed product at such a level that the purchaser cannot remain competitive on the market for the processed product. Meaning the dominant firm squeezes the margin that its rival would earn in the retail market, such that it prevents existing customers from expanding or new competitors from entering into the market. Finally, we have output restrictions under paragraph I, where the dominant entity refuses to supply or restricts access to use of development of a new technology to the detriment of consumers. Remember that this is just a general discussion. You can read the full list of acts of abuse of dominance in Section 15 of the law. Now, even if a dominant entity has committed the prohibited acts of abuse of dominance, Section 15 provides a defense by allowing the dominant firm to show that the complained act has nevertheless contributed to improving production or distribution of goods or services within the relevant market, or promoting technical and economic progress while allowing consumers a fair share of the resulting benefit. In which case, the act may not necessarily be considered an abuse of the dominant position. Finally, moving on to the third pillar of prohibited mergers and acquisitions, we define merger as the joining of two or more entities into an existing entity or to form a new entity. Okay? There's a difference between this in corporation law, mergers and consolidation, but here we treat it as mergers only. Okay? While acquisition refers to the purchase of securities or assets for the purpose of obtaining control of another entity. Okay? Now, if the purchase is simply for investment, that will not be considered as acquisition where the element of control is absent. Okay? So, if it's only for investment, that is not prohibited by the PCA. And for this discussion, I will use the word merger to refer to both mergers and acquisitions. Okay? Now, generally, mergers can benefit consumers because they may lead to businesses that operate more efficiently, enable the transfer of technologies, broaden access to capital, and increase productivity, all of which may result in lower prices for the consumer. However, certain mergers may harm competition and be disadvantageous to consumers, specifically those that are anti-competitive and create companies with dominant market power that lessen, restrict, or prevent market competition. Now, not all mergers are prohibited. Only those which substantially lessen, restrict, or prevent market competition are prohibited. And even these may be allowed if the parties are able to prove that the benefits of the merger in gains in efficiencies are greater than the limitations on competition which it may cause. Or if a party is faced with actual or imminent financial failure and the merger is the least anti-competitive known alternative use of its assets. In this regard, the PCC possesses merger control or the power to review mergers to determine whether it has an adverse effect on competition. In other words, the PCC is empowered to conduct merger review in order to predict the impact of a proposed merger on market competition. How? By obtaining relevant information and data not only from the parties to the merger but also from third parties like suppliers, customers, and others to determine which markets will be affected by the merger, looking at factors such as the number of actual and potential competitors, the barriers to entry, the costs of switching for customers, etc. In short, the PCC determines if the proposed merger will result in a substantial lessening, restricting, or preventing of market competition. And this merger review may be triggered by one of three ways. First, compulsory notification by the merger parties. Second, motu proprio, meaning on the PCC's own initiative. Or third, by third-party complaints. Now, with regard to compulsory notification, the parties to a merger are required to notify the PCC of the merger agreement before they consummate the transaction and actually merge. Okay, when if the size of the party, meaning the value of assets or revenues of the ultimate parent entity and its controlled entities, and size of the transaction, meaning the value of assets or revenues of the acquired entity, okay, they are required to notify the PCC if the size of the party and the size of the transaction both exceed the threshold set by law. Okay? which are adjusted every March 1 of every year and are based on the official estimate by the Philippine Statistics Authority of the nominal gross domestic product of the previous year. At the time of this episode, Commission Resolution number 01-2024, which took effect on March 1, 2024, requires parties to a merger to notify the PCC of the merger agreement when the size of the party or SOP exceeds 7,800,000,000 pesos and when the size of the transaction or SOT exceeds 3,200,000,000 pesos. Okay? The SOP and the SOT tests ensure that only transactions which have a significant impact on the relevant market will be notified to the PCC. Okay? Nevertheless, prior to filing a notification, parties to the merger that are required to notify may inform the PCC of their proposed merger and request a pre-notification consultation, during which the parties may seek non-binding advice on the specific information needed for the notification. So who are the parties required to submit a merger notification? Either the ultimate parent entities or their respective authorized entities of both the acquiring and the acquired parties. In case of a joint venture, the contributing entities are the acquiring entities and the joint venture itself is the acquired entity. Note, however, that joint ventures of private entities formed for both solicited and unsolicited public-private partnerships, PPP projects, okay, these may be exempted from compulsory notification, subject of course to the PCC's discretion. Okay? Other instances that are not subject to compulsory notification include, first, in case of land acquisition, the parties do not have to give notification if the acquiring entity will not gain control over a whole or part of the acquired entity, such as through improvements constituted as operating segments or essential facilities built on that land. And second, in case of merger involving several entities controlled by the same natural person or persons, there is no need to give notice if there is no change in control after the merger. Of course, if there are new shareholders which change the nature of control, then notification is necessary. So, in case notice is required, the merger review procedure goes generally as follows. First, notification. Each party to the merger that requires notification must submit a notification form with the required information and documents and pay the filing fee within 30 days from signing of the merger agreement. Second, determination of sufficiency. After the merging parties submit their accomplished notification form, the PCC has 15 days to determine whether it complies with the requirements. Third, review. If the PCC finds the form sufficient, it will inform the parties and begin phase 1 of the review, which is a 30-day assessment, 30-day assessment, where the PCC will determine whether the proposed merger has a negative impact on competition. Okay? Note, however, that in the following transactions, the parties may apply for an expedited review of mergers, which will take only 15 days for the phase 1 review instead of the 30-day period I mentioned earlier. Okay? In these following transactions, first, parties with no actual or potential overlapping business relationships. Second, foreign entities whose Philippine subsidiaries only act as manufacturers or assemblers of products, at least 95% of which are exported. Third, parties with a global scale but with negligible or limited presence in the Philippines. And fourth, joint ventures formed purely for the construction and development of residential or commercial real estate projects. Okay? If they do not fall under those transactions, then they cannot request the 15-day expedited review. And they will fall under the normal 30-day phase 1 review. So, if the PCC fails to complete its analysis or to make a decision within the 30 days, then the proposed merger or acquisition will be deemed approved and the parties may now proceed to implement it. However, if the PCC determines that after the initial review, a more comprehensive or detailed analysis is needed, then it will notify the parties that it is proceeding to a 60-day phase 2 review, in which case the parties have to pay an additional filing fee. In any case, the entire period of review should not exceed 90 days from determination of sufficiency. Once a merger has received a favorable ruling from the PCC, then it becomes final and cannot be challenged except if it is shown that it was obtained through fraud or false material information. But if the PCC finds the merger would substantially prevent, restrict, or lessen competition in the market, the PCC can prohibit or impose conditions on the merger. Alternatively, the merging parties can propose voluntary commitments to remedy the anti-competitive effects of the merger. And if the PCC accepts these voluntary commitments, then the merger can proceed on the condition that the PCC will monitor the parties after the merger to determine if they have followed through on their commitments. Now, if a party does not agree with the decision of the PCC, it can file a motion for reconsideration within 15 days, and in case of denial, it can appeal to the Court of Appeals. Now, even if a merger is not subject to the compulsory notification requirement, the PCC nevertheless has the authority to initiate a review or investigation on its own to determine whether the merger may result in substantial lessening, restriction, or prevention of market competition. In any case, whether the review is triggered by notification or the PCC's own initiative, the merging parties cannot push through with the merger without the approval of the PCC because they have the obligation to not consummate the merger while waiting for the PCC to clear the transaction. They must continue to operate as separate entities until the merger is approved. If the parties push through with the merger in violation of the compulsory notification requirement by either failing to send the notification or by consummating the merger before approval, this is called gun jumping. And the merger will be considered void and the parties may be held liable for an administrative fine of 1 to 5% of the value of the transaction. Now, violation of the PCA carries with it criminal and administrative penalties. But while the PCC is a quasi-judicial body, it cannot adjudicate criminal cases, meaning it cannot impose imprisonment, even though the PCA provides for imprisonment as a penalty. The PCC is only empowered to impose fines and penalties on businesses whose conduct or activities violate the PCA, or they are in contempt, or they fail to comply with orders, or they supply false or misleading information. In case of criminal cases where the penalty is imprisonment, all the PCC can do is to file the case with the Department of Justice, who will then prosecute the case before the courts following the rules on criminal procedure. So that's it for our overview on Philippine competition law, covering the 3 pillars of prohibited acts, namely anti-competitive agreements, abuse of dominant position, and mergers and acquisitions. Now, I hope you may have learned a thing or two, and I hope to see you next time. See you soon. Bye.